Welcome everyone, thank you for joining me on this August afternoon for the MyHR live video 18. We're nearly at the 20s. The topic today, hopefully as you know, is around medical termination, what it is, when you can use it, how to manage the process and how to manage those challenging conversations you need to have with your team sometime. Before we get stuck in, a bit of housekeeping as always. The video will be available on our YouTube, Facebook and LinkedIn channels afterwards. So if you have technical difficulties or if you couldn't attend or if you want to rewatch it a few times because you've got a slow day, you're very welcome to do that afterwards. Feel free to ask questions as we go through. We'll collate them all and answer them at the end. And of course, you're always welcome to contact us at info@myhr.co.nz after the stream if you have any other questions. This does mean if you do ask questions, of course they'll be on the video, so please be careful not to use identifying information. We won't call you out by full name or anything, just be mindful of the details of your question because it will be recorded. So getting straight into it today, what is medical termination and why is it a thing? We've had quite a massive response to this topic so far, so hopefully you will have some idea of what it is. But it's basically the option to end someone's employment with you if they are unfit to work or if they're incapacitated. And you can consider that when they will never be able to return to work, so they've had quite a serious injury or quite a serious health issue, whether it's or when it's uncertain whether or when they'll be able to return to work or in what capacity, and if their absence from work to deal with their injury or their health issue will be too long for the business to reasonably support. So it's not if someone is sick, we have sick leave for that kind of thing. So if someone's got a really bad case of pneumonia and they're off for 2 weeks, you wouldn't be able to consider medical termination then. And of course, people can accrue up to 20 days of sick leave over the course of their employment. So if someone has sick leave to use, you need to allow them to use it. Medical termination is an option for when there is an ongoing or chronic or really serious issue that you're trying to manage. It's not something to consider just when someone's got a bit of a cough or a bit of a sniffle, as frustrating as that might be, particularly now at the end of winter. A flag to raise kind of early in the piece is that because this is about people's health, and because health can be quite a personal and quite a fraught topic, it can be quite uncomfortable to raise with your employees. So don't expect this to be necessarily a comfortable conversation. But on the flip side, if someone has had something quite challenging happen to them that's been out of their control, it's an illness, it's an injury or what have you, it can be an easier conversation to have because it's not about their performance or the need for them at work, it's about their health and their well-being. So it's not always a fun conversation, but depending on the circumstances it can be less fraught because you're dealing with something on the facts, I guess, which are more objective and less subjective than performance would be. So when can you consider medical termination? Under what circumstances can you look at it? The question that you're asking as a business owner or as a manager really is, can the business sustain their absence from work? That's the key question that you're trying to answer. It's not about let's punish someone for being absent or let's punish someone for having had health issues. You're looking forward, given what you know about their medical circumstances, and assessing if they will be able to come back to work in a time that you can manage, you can find cover for, or you can reassign their duties. And the longer it is going to take for them to recover, the more likely it will be that you'll look to terminate their employment for medical incapacity. So it's a how long is a piece of string question, as always with these types of things. As a guide, case law says that a 12-week absence in most circumstances is reasonable, and 12 weeks is 3 months. Like, that is a long time for a small to medium business. So it really does depend on how big your business is, what size the team is, whether they're in a key or a crucial role, or whether they're in a role that's easy to replace. So there is a lot that depends on the particular circumstances of this employee and their health circumstances. So that 12-week absence is generally considered a guide. You can drop that down in your employment agreements or in your policy. Our employment agreements by default say 5 weeks of absence, which is the 4 weeks of sick leave plus a week for good faith. So the 12-week piece may not apply, but it's kind of the guide from case law, which is to say that it's reasonable for an employee to be away for 12 weeks if they're recovering. The specifics will include, or the specifics facts that you will be considering for a particular employee include what's in their employment agreement, so what have you edited or what have they agreed to, what's in your policies if you have a rehabilitation or return to work policy that you abide by, and how you've treated other employees in the past. Again, this employee may have a particular condition that means you do treat them differently, but how you've treated others in the past will definitely play into that picture that you're considering. So basically, if they're absent from work due to injury or sickness or other health issues like depression or anxiety or mental health conditions would be unreasonable for you as a business to support, that's when you're considering that medical termination piece. So just to recap, it's not about punishing them for being absent or being unwell. It's about looking to the future and practically what your business can support and what length of absence you can sustain. So as always, we talk about process a lot in HR, and this situation is no exception. You can do whatever you want all the time. As a business owner, you could totally call someone up and go, I don't like the cut of your shirts these days, you're fired, I'm going to let you go. You can do that, no one's stopping you. What you can't avoid are consequences for that behaviour. So you would very likely be facing down a personal grievance for firing someone based on how they dressed or whatever the other circumstances are. So when you're managing these types of processes, what you're trying to do is limit or manage the risk from the steps you're about to take. You can always do whatever you want, but to manage things fairly and to avoid that legal risk, these are the steps to follow, or these are the boxes to tick. And remembering that a fair process is just as important as having good grounds for proceeding with whatever you're doing. Someone might have been in a car accident and has some really, really broken legs. They work as a production operator, so they need to be on their feet a lot. That's perfectly good reason for going ahead with a medical termination process. If you just called them and told them they were fired, you have as badly set yourself up as if they didn't have those broken legs in the first place. So the grounds and the reason for going ahead with the process is as important as the process and the way that you manage that departure itself. So they're equally important. So a really quick list of the things to tick if you are going through a medical termination process. You must give the employee reasonable time to recover. And again, what reasonable time is will depend on the circumstances, but you must give them some time to recover. Secondly, you must go through a fair inquiry into their circumstances, into their health, into their needs, what rehabilitation support you might be able to provide before you then make a decision to dismiss. So you have to balance their circumstances and also the needs of the business. Thirdly, you need to let the employee know that there's a chance they might lose their job for this. It sounds like it's quite obvious, but the number of times we see a process where the employer or the business is consulting with the employee, talking about their health, talking about how it's problematic, but at no point have said, if we can't come to an agreement here, you might lose your job, is quite astoundingly high. So make sure you let the employee know a consequence might be that their employment ends. Fourth, you must give them a fair chance to give you their feedback or give you their suggestions for consideration. So that's no different to a restructure process, a disciplinary, whatever other consultation process you're running. The employee has the right to give you a reply to your concerns, give you some suggestions, engage with you in a conversation about what that might look like. So giving them a chance to give you their feedback is really important. Next, you want to consider their length of service and whether you contributed to the injury or the illness or not. So if an employee's been a long-standing loyal employee to you, or if you have contributed in any way to the injury or the illness, if it's a work-related injury, if both of those are true, those factors will heighten your obligation to the employee and mean that you will need to tread quite carefully when considering terminating their employment. Seek advice about that. We're here to help if you're a client of ours. Give us a call if you're not, and we can talk. But do be mindful that if they've been an employee for a longer period of time, the threshold you will need to meet to show that it's unreasonable for you to manage their absence or their anticipated absence is quite a bit higher. And lastly, you need to consider if there are alternative duties open and available to that employee. So if there is another working arrangement that you can piece together, which might be different hours, different duties, a different location, a staggered return to work if they're recovering from an injury, if you can piece together some arrangement that's acceptable to cover from now until when they're expected to be fully recovered, you'll need to be really, really clear as to why that alternative arrangement is not acceptable if you are considering medical termination. So there's someone who's unwell, who's had an injury, you've gone through a fair process, you've had the conversation with them, and now you're coming to a point where you're making a decision about what to do next. So consider all the information available. Are there other arrangements you can make? Has your process been robust and fair? Do you have enough medical information to assess their return to work? A medical certificate from a GP that just says so-and-so is unfit for work and is due to return on the 1st of September is not going to be enough information for you to make a decision, because you don't have a sense of what the problem is, what other support they might need. So making sure you have that medical information is really important. You can always contact, with the employee's permission, their medical provider or their surgeon or their physio or their kind of primary medical carer to further understand the situation. That's totally fine, particularly if the employee isn't giving you that information themselves. You can investigate further to understand. When you are considering termination of employment, you're not required to pay out their notice period if they're not currently at work, because they aren't available to attend those hours of work, so you don't need to pay them for them. It's generally quite kind if you do, because this person is clearly unwell or has not had a good time of it, so paying them for their notice period is a generous offer to make, but it's not one that you need to make under all circumstances. So that's kind of what you're considering, that's the process. What risk are you trying to manage? What's the worst case scenario here, and why are we taking you through or advising that you go through a reasonably extended consultation process? The personal grievance is the main one, of course. So employees who aren't fairly taken through a dismissal process can take a personal grievance for unjustified dismissal, unjustified disadvantage, potential breach of contract, and potential breach of good faith as well. It depends on the circumstances, of course, but the thing that we know for sure is that penalties in the Employment Relations Authority and the Employment Court have been increasing over the last 2 years. So you stand to risk quite a sum of money if you get this type of thing wrong. That might be, well, what was the last one we saw? The last payment we saw come out was in the realm of $18,000 to $19,000. I don't have an exact figure, but it was quite high. And the number of payments being made, the number of penalties being awarded for above $25,000 are increasing kind of by the month. So personal grievances are the main risk. You're also trying to manage your reputation as an employer in the market. If you're known for treating your employees unfairly, that can go badly wrong. So there's a few pieces that you're looking to manage there. Well, thank you for your time and attendance today. It looks like we may have had some unreliable sound issues going on, so we'll put up a transcript afterwards to make sure that content's available.